But the city has to follow its own precedent in public hearing processes. They've always had a precedent to grant a public testimony during the comment review period. They're not doing that. They're arbitrarily ignoring their own precedent they've set.
But is that required by law?
Yes, absolutely it is. And very definitely, state law. CEQA requires it. And it is absolutely something we will fight in court if we need to.
Is it something that has to be done during the planning commission stage or during the
whatever the city's precedent is throughout the planning process? And historically, I don't know of one case, and I'd be hard pressed if they could come up with one or two. The vast majority is they have always had a public comment period or an open public hearing during the public comment period.
Okay, but my point is you can have a precedent and not have it be a law. It could be something that the city
does
as part of its process.
They must follow their precedent. If you want a clarification from our attorney, I will see if I can get one from him today. Okay, I just don't know what else to say.
How's the mold situation over there?
The what?
It's mold that's still around here, which is not good for.
I have no idea.
You never heard of that?
No. In this city hall building?
Different places or over
I don't know. I don't know. Anyone? Yes.
Is it clear to you, or does it seem evident that there's already 2 city council members that have already made up their minds on this project?
You know, I'm not going to comment on that right now. We will comment on that at some point in the future, but I don't want to take the focus off of what this is today.
You said that you're prepared to fight this in court if needed. At what point would you start to do that? Does the city have to comply with each of these things that you've mentioned today?
Well, the city has to take an action before we can fight it in court. So, you know, I don't know. But all of these things will build that case that we take to court if they don't treat us fairly.
When you're talking about the Americans with Disabilities Act, because someone doesn't have a computer, is that part of ADA? That would be interesting.
They need to have access to the documents. Historically, another precedent, they've always noticed and posted environmental reports at all the public libraries in all the cities. That's actually in this letter also, if you got that. For some reason, they did not put it in New Hall and Candy Country. We had people that went to Candy Country and there's no environmental review document for them to get there. When we asked for it from the city, they gave us CD-ROMs. Those people weren't able to use that. Don't know about ADA. Again, it's in the letter.
I did.
Yeah, it's in there.
So if this was available June 26th, why are you waiting till this moment to bring this up? Because you don't, there's not much time to get something done.
Yeah, well, you know, and this is something we realized this window was closing, and we wanted to get comments in that we haven't had time to complete, and we don't understand. One of the things that came up in our review of the environmental report was that the conditional use permit was withdrawn. That's a brand new component, never discussed at previous hearings. We just discovered that a week and a half ago. It's not in the, you know, we're always looking at the details and the environmental specs. This is all at the beginning under the historical review. We started reading through that.
Doesn't sound good.
Well, that wasn't my car.
Yeah. We started looking through that and realized that had been changed, and we don't understand the precedent. And let me just say this. Let me give you an example of what that precedent could set. If the city is going to say, well, this is going to be a master plan and that's the entitlement we're going to give it, then what's to stop them from taking any strip of land in the city, putting in the middle of a residential area and putting a master plan mall there and saying, well, it's a master plan. So we don't have to pay attention to any of the zoning, which is ordinance, which has a bigger precedent than their master plan resolution. They cannot do that. We don't understand how they're doing it. We don't even know what to comment on because we don't even understand what the master plan is. What is the document that details how the conditions are spelled out that were spelled out in the conditional use permit that no longer applies?
There's too much leeway, basically.
There's too much. There's no defined content of what this thing is, and we're supposed to comment.
Okay, so what you're saying is, from the last hearing that was done at the city council, there have been a lot of changes that are in this document that have never been discussed before.
The most fundamental application of this project was on a conditional use permit. The whole thing, the way they ran this through City Hall was a conditional use permit. Something typically used if you have a retail store you want to open, but you want to make it a liquor store, you have to go get a conditional use permit to do that. They took that kind of a planning law or a permit and took a 1 million square foot project and tried to cram it under that same permit.
Right.
Now suddenly they've withdrawn that permit and they're saying, well, no, this is now a master plan. This is going to be a master plan entitlement. It's redundant to have the permit. We can do this all with a master plan. We don't understand how.
But are your objections, it seems like it's more about the process than it is about what is in the document itself.
It's both. It's both. The process allows us to understand what's in the document
This is
itself.
just a
That's why you
specific
have
case.
that's why you have a 45-day review period, and that's why they have to respond in writing. Okay, we don't have the information in front of us. They haven't provided the presentations, the analysis, any of the things that we need to make a case to ask even the right questions. That's unprecedented, and it's totally without merit, and certainly defies common sense.
So you're saying that EIR, not only is it insufficient, but there's not enough time to go through it.
I'm not going to comment on whether it's sufficient or not. We're still going through it. We're still conducting studies on it. We still need information from the city on what they're doing. They just hijacked the process by changing this right now and not giving the public any explanation of what they did. I have a feeling that among our most influential in the city, which are all the lobbyists, probably had some meetings and had something to do with that, though.
Correct.
Okay, that's it. Thank you.
One question.
Thank you.
Yes.
Any of the property that they're acquiring, any of it, would it be historical landmarks?
I don't think so. I don't think so.
Not even an individual structure?
Only my house would be a historical landmark because
Yeah,
my
I don't know
house
if
was
any
there
of that
before
stuff's
the hospital
Well,
was.
if you declared a